Hi, I'm Sean Dong, Senior Lawyer and Director at Proactive Legal. We are a boutique law firm specializing in complex migration matters. Today, I'll briefly talk about the character requirements in Australian migration law. Character issues are important for all visa holders in Australia. If a visa applicant or holder has a criminal conviction, it can lead to visa refusal or cancellation, and even a lifetime ban from entering Australia. So it is a serious matter. How does a character assessment work exactly? Let me explain. First, there is a character test. If someone does not pass a character test, the visa could be refused or cancelled under Section 501 of the Immigration Act 1958. How could someone fail the character test? The most common reasons is having a substantial criminal record. If someone has been sentenced to imprisonment for 12 months or more, it is considered a substantial criminal record, and they fail the character test. You must count the entire sentence, not just the time actually spent in prison. For example, periods on parole and suspended sentences are counted as imprisonment for migration purposes. That means someone who has not spent a single day in prison could still fail the character test. In addition, some specific offences could lead to failure of a character test, regardless the length of the imprisonment. Examples including human trafficking, sexually based offences involving a child, or being a subject of an Interpol Red Notice. The department may also consider the applicant's general behaviour. This is a broad discretion, and the minister can basically take anything into consideration. That being said, it does not give the minister unlimited power to cancel a visa over minor and non-repetitive offences. It is governed by case law and the Ministerial Direction 110. If a case officer thinks someone does not pass a character test, the case will be referred to the Visa Applicant Character Consideration Unit, or the VACCU, to decide whether the visa should be refused on character grounds, or the National Character Consideration Centre NCCC for visa cancellation if it's a visa holder. Now let's talk about how character considerations are assessed. It comes down to one important document, currently called the Ministerial Direction 110. In this direction, the Minister has given 5 primary and 3 secondary considerations on how the character test is applied. The 5 primary considerations are protection of the Australian community from criminal and other serious conduct, whether the conduct engaged constitutes family violence, the strength, nature, duration of the ties to Australia, the best interests of Australian minor children in Australia, and finally, the expectations of the Australian community. The 3 secondary considerations are legal consequences of the decision, extent of impediment if removed, and impact on Australian business interests. Under Section 5011, the Department has discretionary power to refuse or cancel a visa. This means the Department will consider the records and the consideration outlined in Direction 110, then decide whether to refuse or cancel a visa. However, under Section 5013A, if the visa holder has been found to have a substantial criminal record or has been involved in a sexually based offence involving a child, the visa will be mandatorily cancelled while the person is in prison. However, they can apply for revocation after the visa is cancelled. It is also assessed according to Direction 110. But the mandatory cancellation means that if the offender finishes serving their sentence, and if the revocation decision has not been made yet, they must wait in the immigration detention facility for the safety of Australian community.